Next, we're going to talk about 403B issues, and specifically the ability to terminate a 403B plan. Regulations do allow for termination of the 403B plan if the plan document, first of all, specifically permits plan termination. So it has to be the plan document, but prior to new regulations had been being promulgated, the termination of the 403B plan was not permitted. So you want to make sure, since there's new regulations, that the plan document does allow for termination of the 403B plan before considering termination. The group annuity contract versus individual contracts. We see both of these often in 403B plans. So the group annuity contract, first we'll talk about the group annuity contract, may easily be terminated by fully distributing all assets, providing ongoing 5500s and a final the year that termination is made, and providing a 402F notice, which is a notice of rollover options and the tax consequences, and also participants may roll over but not transfer to a 401k plan. Now that's for group annuity contracts. Now let's talk about the individual contract conversion for 403B plans. And here, curiously, the IRS has not yet resolved whether individual contracts may continue to exist after a termination, assuming the plan can be terminated, and the employee should be informed of their ability to roll over within 60 days to avoid tax consequences. And that's considered legally under ERISA to be the conservative approach when terminating individual 403B contracts. But there's also an aggressive option. The more aggressive ERISA attorney opinion suggests that the plan may be terminated if only you're notifying the participants and providers and treat individual contracts as distributed, and distributions will then be reported by the provider in a form of a 1099-R. 403B plans may be frozen, and the considerations are exactly the same as those considerations for 401k plans. So no need to revisit that. Now we're going to talk briefly about defined benefit plans, because we don't work as frequently in defined benefit plans, certainly as we do with DC plans. But with respect to DB plans, termination is allowed, obviously. But number one, the plan must be fully funded. Number two, it must make full distribution of all accrued benefits depending on what the plan document allows for lump sum, annuity, annuitization, etc. 100% vesting, obviously. Ongoing 5500s must be recorded, and the final 5500 as well must be sent, and all PBGC premiums must be paid. That's the Pension Benefit Guaranty Corporation, the insurance that fund that participants will receive their appropriate funding benefit. You can also freeze a DB plan, which many plans have done. And there's three types of freezing. One is considered a hard freeze. With a hard freeze, no additional benefits accrue either due to service or compensation until the plan is documented as frozen. There's a soft freeze, which increases in accrual of benefits are limited for current participants only, no new participants. And then there's a partial freeze. A partial freeze, only a subset of participants that you deem to be non-frozen will continue to accrue benefits. And the caveat here is under 40, excluded or not eligible, excluded. There are some more considerations. One is that of continued compliance, so all the legal and administrative and fiduciary responsibilities continue. The 204H notice, which is a notice of reduction in rate of accrual, is appropriate as to be distributed. Summary material modifications, ongoing and final 5500 PBGC insurance premiums must be paid. Non-discrimination testing must occur, and tracking of age compensation and service responsibilities as well. So we have action steps here in the event of a consideration of plan termination, merger, transfer, spinoff, and that is the obvious. Be aware of corporate transactions that may affect qualified retirement plans before transactions close for maximum planning and fiduciary liability flexibility. Again, the only time a fiduciary liability doesn't transfer to the buyer's plan is if that is the seller's plan terminated prior to acquisition. When a planned transaction with the plan starts with the advisors and the ERISA counsel, contact them, consult with them to ensure that all legal requirements are met.